One of the most interesting questions about Chapter 15 is percolating itself through the 11th Circuit Court of Appeals, which sits in Atlanta. For those of you who don't often work on cross-border insolvency, Chapter 15 is the portion of the Federal Bankruptcy Code that allows a trustee in a bankruptcy abroad to come to the U.S. and get recognition of that foreign bankruptcy in the United States. Recognition automatically imposes the automatic stay, as we all know it, and in addition, recognition allows that trustee from abroad to take discovery and chase assets in the United States. And perhaps most importantly, recognition enforces the decisions of that foreign bankruptcy court in the United States. The question before the 11th Circuit is one on which there is an outstanding split of circuits. Some years ago, the 11th Circuit held under the former Section 304, which was the predecessor to our current Chapter 15, that the definition of a debtor in the Bankruptcy Code does not apply in one of these cross-border cases. The definition of a debtor, as you know, requires that the debtor have assets in the United States or be a resident or domiciliary in the United States. Then, not too many years ago, the Second Circuit held quite to the contrary. The Second Circuit held that someone who has no assets in the United States is not eligible to be the debtor in a Chapter 15 case. The very same issue worked its way up to the 11th Circuit again. This time, all three judges on the 11th Circuit panel decided that they were bound by that original decision by the 11th Circuit under the former Section 304, and so they upheld the two lower courts and their findings that it was proper to recognize that foreign bankruptcy, even though that debtor had no assets in the United States. As I said, that set up a split of circuits with the Second Circuit, which had held that the debtor must have assets in the United States before there can be a recognition of that foreign bankruptcy. Now, here's what's really interesting about that 11th Circuit decision. One of the judges, although saying she was bound by the prior 11th Circuit decision, said that if she were not bound by that prior decision, she would have held quite to the contrary, agreed with the Second Circuit, and precluded those foreign bankruptcy trustees from having recognition in the United States. But that wasn't all. There was a third judge on that 11th Circuit panel who said that he would follow the very same decision years ago from the 11th Circuit and allow recognition. Now, what we have right now is a flat-footed split of circuits. I am pretty sure that this divided 11th Circuit panel is going to importune the debtor in that case to file a petition for rehearing en banc, which would mean, if granted, that all of the judges on the 11th Circuit will sit together on a bench, hear argument, and decide whether or not they're going to agree with the Second Circuit. Now, especially if the 11th Circuit either doesn't hold rehearing en banc or agrees with its prior decision, we have a flat-footed split of circuits, and that, I think, is most assuredly going to give us a petition for certiorari for the United States Supreme Court to decide whom to follow. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will give further reports in coming weeks and months about what happens with this 11th Circuit case. In the meantime, be well, stay safe, and a very good day.